the keynote lecture of a specific event. We have different formats and different types of presentations at the NCCR. We have, I'd say, the flagship of the NCCR is, of course, the public lecture series. But this keynote is indeed public, but it is also the keynote lecture of an upcoming event, an upcoming workshop, which will take place on Thursday and Friday this week at the NCCR, entitled The Mobility Challenge to Welfare, Historical and Comparative Insights from Europe. And we have today two speakers. First speaker, who will do most of the work, speak for about 45 minutes, is Francesco Maiani, who's Associate Professor of European Union Law at the University of Lausanne. And he has published extensively on EU constitutional law and international migration law, and is also, incidentally, currently co-directing an NCCR project on welfare, inclusion and solidarity, together with his colleague, Professor Giuliano Bonolli from the University of Lausanne. We also have a second speaker, and we're very grateful to you, Jean-Michel, for accepting to step in and provide us with your comments and your views on Francesco's presentation. So Jean-Michel is a dear friend of mine, as well as a research professor at the University of Liège. He's also the associate director of the CEDEM, which is the Migration and Ethnic Studies Research Institute at the University of Liège. And he's currently about to finish, I guess, imminently, an ERC-funded project on migration and transnational social protection in post-crisis Europe, which has led to many publications. And in particular, I would like to highlight the recent publication in the fall of 3 edited volumes by Springer, comparing in a very comprehensive way the access to social protection only of immigrants, but also of immigrants in the European Union, as well as in selected countries. So, Francesco, your talk today is entitled, provided that the title hasn't changed.
It hasn't.
It hasn't. Excellent. So let me just tell the title before giving you the floor. So it's entitled Europe, Welfare and Mobility from Closure to Openness and Back Again. I'd like to warn you that the talk is also being streamed live on the NCCR YouTube channel, and it's also being recorded. So if any of you does not want to appear on YouTube for whatever reason, then please switch off your camera. So we'll proceed as follows. We'll have a presentation for about 45 minutes, I guess, with a PowerPoint presentation. Francesco had an excellent paper, which he made available to some of us, but unfortunately the paper is being reviewed and we have to respect the secrecy of the reviewing process, and therefore it's not, up for reading by everyone, but I guess in a few months it will eventually come out and you'll all get a chance to indulge in the memory of that lecture by reading the actual paper. So Francesco will talk for about 45 minutes, then we'll get feedback and comments by Jean-Michel for about 10 minutes, and then we'll open the floor to the rest of the audience. You may either raise your hand, I guess you're all familiar by now with how that all works. You may either raise your hand in the chat so that you can spell out your question, or you may write it in the chat as well, and then I'll just collect and summarize and pass it on to the speakers. So, well, I guess we can now start. I spoke for exactly 4 minutes. Francesco, the floor is yours for about 45.
Thank you very much, Jean-Thomas. I am extremely honored to be the keynote for this event, the keynote speaker, and very glad to be with all of you. I see in particular my dear colleague and collaborator, Angie Gago, who is online today with us, and who is the co-author of the article on which my presentation is based today. I would like to stress 2 things. First of all, please note that at the end of my title, there is a question mark, and the question mark is kind of important in what I'm trying to convey, which is that, in fact, the evolution of EU law in this area cannot be depicted so simply as a movement from closure to openness and back again, or at the very least, there are some qualification and a bit of nuance to introduce in the picture. The second thing is that I have a fairly utilitarian approach to slides, and I tend to use slides when I have a peculiar structure to present or when I have data to show. But in this case, it's not the case. And what I want to do is to broadly depict the scenario against which you are going to hold the event, which means that I do not want to project slides today, even though if you so wish, I may provide and circulate for reference a detailed handout of the things that I am going to say. So having said that, let me start by take as my starting point welfare tourism as an issue in general and as a topic in EU integration. Welfare tourism is one of those bugbears that exist in the realm of social policy. It is something that is largely assumed to be there. Then empirical data don't really support the existence of welfare tourism, but still it is a force driving policy making and policy evolution. It's much like, I mean, there is another policy area in which I'm very active, which is asylum, and there the correspondent to that is what in French is called appel d'air or pull factors in English. They're always assumed to be there. They tend to drive politics, even though the empirical evidence behind all that is quite scant. So what is welfare tourism? Well, welfare tourism can be defined in several ways, but by and large, it's the idea that people move from low-income countries, or at least from a situation of poverty in which they find themselves, they move to another state, not to work there and to contribute to the national economy, but rather to enjoy the benefits of a generous welfare system. This is by and large the idea, and it is an issue that has been for a large part of the history of European integration, which is our focus today, implied. It was not stated as such, it was implied in the structure of EU law, free movement law, as it evolved over the first decades. And it then surfaced very strongly in the 1990s with the extension of free movement rights to what we may call non-active citizens, that is, persons who do not pursue an economic activity, and job seekers, meaning persons who are out of work and looking for one in the host state. And then it became an even more salient issue when we came to the enlargement of the European Union to Central and Eastern Europe. Why is that so? Well, because it was to be one of the biggest enlargements in the history of Europe, and one that would dramatically increase the differentials of wage inside the European Union. So many member states undertook a whole spectrum of reforms to counter the threat of welfare tourism. And this, of course, was something that was seen as potentially problematic under EU law, because EU law is all about opening free movement and non-discrimination. And so all these issues came again before the European Court of Justice, and the whole thing became topical once again in the 2010s, when all the legal disputes that had been generated by the reforms of the years 2000 eventually came before the European Court of Justice. And the European Court of Justice, to the surprise and outrage of many, including many legal commentators, upheld the compatibility of all this new legislation, which was meant to counter welfare tourism, with EU law. The central reference here is the very famous judgment given by the court in 2014 in the Dano case. So what I'm going to try to do in the 40 minutes that are coming is to try to detail this kind of legal evolution that I have just outlined now, and to analyze it from the standpoint of its being a turning point, a striking break, a major shift or a major change in the history of European integration. And if there was a change, and to the extent that there was a change, to try to make sense of it and to try to understand what could explain it. And the background to these questions that I'm going to examine is that this case law, this more recent case law from 2014 onwards, or according to some, you should put the the calendar back to 2012 for this new phase, has become extremely controversial, very much commented upon. It was very often depicted as a striking break, and here I am quoting, inaugurating a reactionary phase, and here I am quoting again from a very nice article by Eleanor Spaventa in 2017, and from an equally impressive article from Blauberger and others in 2018. So it's often depicted as a big U-turn, and even as something of a legal puzzle, as if the European Court of Justice had done this in a way that was legally indefensible and just caving into political pressure, or maybe putting the ear to the ground in order to detect a shift in public opinion against free movers and against welfare tourism. So there are this general depiction is that the court took a big break, that this is somehow legally puzzling, and that there were political motives behind this of the kind of the court trying to accommodate increasingly Eurosceptical public opinions. So what I will try to do is to try to critically assess these ideas, but in order to do this, I need to do the typical lawyer's job, which is perhaps not much loved by all the social scientists who are following this keynote, and that is to set out the legal situation and to try to map its evolution over time. Of course, there will be no time to go into any details, but I will try to give you the general direction of change so that we can all then try to assess these questions of whether there was a striking break, how much change there was, and how we can make sense of it. And in order to do this, I have kind of broken down my presentation into a few periods. There is the period of which serves mostly as a background, which is from closure to openness by virtue of European integration happening, and I will then insert in there under the title "More Openness: The Heroic Case Law of the 90s and 2000s," what is depicted as the heroic phase or the progressive phase of the European Court. Then I will stop to consider the very important directive adopted in 2004 and the case law that came immediately after that. So the case law of the second half of the 2000s, and then eventually we will come to the last phase, the phase of the Dano case law, and we will examine whether it was a restrictionist U-turn. Okay, so let's go all the way back to the beginnings of EU law, and let's contemplate for a moment the situation that there was initially. When I say in the title "From Closer to Openness," what I'm referring to in terms of closure is just the initial state existing in the member states before European integration. And I will not go into too many details. I'm just referring to the traditional aspects of national welfare systems, which is that they reserve the advantages to those who are territorially present, or at times who are present in a qualified manner, for instance, resident from 5 years, or even reserving some benefits, those that are closely linked to notions of national solidarity, to fellow citizens, to the members of the national community. And of course, we could introduce many, many nuances here, because national welfare systems all differ in this respect between themselves. But the point that is interesting to me is that EU law and the EU integration project was designed precisely to pry open that kind of closure by relying on two core elements that will recur over all of my presentation. One is rights to mobility, free movement, and the other one is the right to non-discrimination, including in welfare issues. Okay, so if we go back to the start of integration and to the first, let's say, 30 years of integration, the phase that we could call of classic community law. The phase of classic community law is one where only economic actors and their families, of course, enjoy free movement and equal access to welfare. In this context, the issue of welfare tourism can hardly become a prominent issue, because the general starting point is one where we as the host state community, grant full equality in welfare matters to persons who come here to be integrated fully in our labor market and who contribute to the welfare system through their contributions, through their taxes, or through their cotisation and whatever. Okay. Well, of course, this is to a large extent an ideal type, because over time the European Court of Justice has interpreted very widely both the notion of who is a worker who is entitled to equal social advantages and the notion of social advantages themselves, so that over time we have come to a situation where even persons who are in a relatively marginal position in the labor market, the working poor, could fully benefit from the benefits of European community law. Okay. But this did not give rise to much discussion, in fact, comparatively. Yes, the member states always tried to interpret away their obligations, always tried to advocate for restrictive interpretations, but there was no fundamental contestation of the whole building of European community law, and there was no big alarm around the issue of welfare tourism. And interestingly, the basic structure of European community law was unaltered when in the 1990s there was the shift towards the idea that free movement was a citizenship right. So at the end of the 80s and at the beginning of the 90s, there is this very important shift in European integration whereby the right to move to another state is opened to persons who are not economic actors. This was first in the legislation and then in the treaty. And there is also another shift that is more known to specialists and less to the general public, but which was equally important, which is that the European Court, in its case law, starting from the Antonissen case at the very end of the 1980s, starts saying, well, job seekers are a kind of worker. They also have a right to go in the other member states to look for a job. Okay. And one may think that this would have raised the problem of welfare tourism, but it wasn't so, in fact, for a very simple reason, that both the legislation extending the right to free movement to inactive citizens and the case law extending free movement to job seekers took care to point out that these categories of persons did not have full access to welfare benefits in the host state. Okay. Actually, the case law really pointed out that job seekers are to be considered as workers except for access to welfare benefits, but they only had the right to be treated equally in accessing the labor market. Okay. And the directive said, well, inactive citizens can stay, but they only can stay so long as they have sufficient resources so as not to become a burden on the welfare of the host state. Okay. So this was a relatively clear and simple, if perhaps rudimentary, legal framework in which you had the economic active who were driving in the Rolls-Royce of European free movement law, and they had all the benefits, including welfare access, and you had the inactive and the job seekers who could move across Europe, but were in principle outside of the welfare system of the host state. And this is the legal context within which the so-called heroic or progressive or constituent case law of the European Court of Justice has been established. And I am talking about the case law that developed in the period of time between 98 and 2005, or 2004, perhaps, if we take Collins as the last element. And since this is the case law against which Dano is usually contrasted, I think that it's useful to just stop a moment and consider it, and consider the main acquis of this phase of the case law. The most famous judgment of this heroic phase is probably Martinez Allah. Martinez Allah is a judgment of 1998. And what the court said in Martinez Allah was apparently quite revolutionary, because the court came to the conclusion that any EU citizen who was staying legally in another member state was entitled to invoke non-discrimination in regard to all the benefits that are covered in whatever manner by EU law, meaning also all those welfare benefits that were in principle reserved to workers only. Okay, so starting from Martinez Allah, the case law appeared to say, and I would suggest that appeared is the important word in the context, appeared to say that any EU citizen who is legally residing in a member state has the right to claim equal access to basically all welfare benefits. Okay. Then you have another important case that is very famous for the rhetoric that the court used. It's the case where the court said, and the phrase is most beautiful in French, so I will say it in French, that the EU citizen has a right to un certain degré de solidarité in all the member states where it is present, even if it is an inactive citizen, and so should in principle have its own sufficient resources. In fact, Drelchik was the case that established that a member state cannot automatically expel a non-active citizen who requests social assistance. Okay, and so that the lack of sufficient resources cannot be automatically found to exist whenever an EU citizen asks for a benefit. And so on and so forth. There were at least two other important judgments. One was Bidar, in which the court said that EU citizens who are students are in principle entitled to student grants, subject to the right of member state to require, I'm quoting, a certain degree of integration in the host state. Okay. And lastly, Collins was the case that went beyond the old Antonissen case law that I mentioned before, in which the court said, well, if we look at the whole development of EU law so far in the last 10 years, we can say that, yes, the old case law said that job seekers can be completely excluded from welfare benefits, but looking at how EU law has evolved, I say that they cannot be excluded from those benefits that are established in order to favor the entry of a newcomer on the labor market. So what was called financial benefits intended to facilitate access to employment in the labor market. Again, saying, however, that the member states could exclude the job seekers that did not have a genuine link with the local market. You may be wondering, why am I bugging you all with all these legal details and all this case law? Well, the reason is fairly simple, because I want to make a few points. The first point is that indeed the case law of this period gave a progressive reading of the legislation. One could argue whether in some cases it went beyond and kind of flew in the face of the legal framework as it existed. I mean, take Martinez Allah. You have legislation saying that non-active citizens must have sufficient resources in order to stay, and the whole thing is part of a legal scheme where there is a sharp division between economically active and inactive. And here comes the court telling us that any citizen who is legally staying has the right to obtain, in principle, equal treatment in all welfare matters. It was shocking to legal doctrine at the time. However, then, so this whole case law is progressive. But the point is that it was not as radical and as clear-cut as it may seem. First of all, just to start with Martinez Allah, it was clear that the Martinez Allah logic was, as long as you have this EU citizen living legally on your territory, you have to grant equal treatment. But you can still kick them out. This was explicitly stated in Troiani. They have no right to stay under EU law because they don't have sufficient resources, so the member state is entitled to, accompany them to the door. This one point that was less publicized of Martinez Allah. Another point is that it was, if you look at the whole case law, it was not really clear that Martinez Allah was the dominant case law. Because, for instance, in Drelchik, the court said, well, yes, EU citizens have a right to non-discrimination that extends to welfare benefits, but this applies if those citizens have a right to be there under EU law. Not merely because they are legally there, but because they have a right under EU law to be there. Now, this may sound to you as the kind of subtle distinctions that give lawyers a bad name. But in actual fact, it's a fairly important one, because if you say that EU citizens have in principle the right to non-discrimination only if they fulfill the conditions of EU free movement, you are saying that only those who have sufficient resources, basically, can access the welfare state of the host system. Okay, those who have no sufficient resources don't have the right to be there, and so they don't have the right to non-discrimination. And in this case law, it was unclear which logic the court was applying in this period of case law. Final point, very important. Even when the court recognized a right, the right to equal treatment in respect to this or that welfare benefit, at the same time, it always recognized to the member state the possibility to make exceptions, so long as these were justified. And the grounds of justification were notoriously fuzzy. So, for instance, for job seekers, well, the member state could exclude those that did not have a genuine link to the local labor market. Okay, what is a genuine link exactly? Or for students, yes, there is a right to have the grant, but member states can exclude those who don't show a sufficient level of integration. Okay, what is a sufficient level of integration? So if you peel the onion, it turns out that this heroic case law was progressive, but it was not as monolithic as many would have it. It was full of, under the surface tension and contradictions, and certainly there was a lot of room for member states to limit those rights. Okay? Enough of this. Let's move to the new page and to the second half of the years 2000. Also because I'm looking at the clock and I see that I think I used up already 20 minutes of my presentation. So I had better keep moving. So just 1 month after the last judgment I mentioned was given, Collins, and right before, days before the enlargement became effective, the EU legislation recast completely existing free movement law, especially by adopting the famous citizenship, so-called directive. At least it's called like this in the whole debate that is taking place in Switzerland. One could perhaps call it the free movement directive, but whatever you call it, it's from 2004, and it came exactly at that turning point in history. And it was no mere accident that the directive would be adopted just days before the enlargement set in. To a large extent, the directive was a restatement of the old law. It was just a way of presenting it in a more codified, in a more streamlined way, and also to take the occasion to codify some progressive elements from the case law that I just described. So, for instance, there is one provision which really just codifies the principle that the European Court laid down in the Drelchik judgment. Okay. But at the same time, the new directive reflected very clearly the fears of the member states in regard of welfare tourism and tried to accommodate them. First of all, this also belongs to the restatement category, but it restated and perhaps emphasized a little bit more than was hitherto the case, the condition of sufficient resources for non-active citizens and the importance that this condition had in order to preserve the public finances of the host states. But other than restating this classic element of free movement law, there was a new provision, Article 24(2), that seemed to introduce brand new exclusions in the realm of access to welfare. On the one hand, Article 24(2) authorized the host state to exclude from, I quote, social assistance, both inactive EU citizens in the first month of their stay, so during the period when they would not be subject to the condition of having sufficient resources, and job seekers. So to repeat the point, because otherwise it will become to follow afterwards, the new directive foresaw that inactive citizens could stay without conditions in the first 3 months, and that then they would be subjected for longer stays to the condition of sufficient resources. But then you have Article 24(2) that says, well, during the first months of stay, inactive citizens may be excluded from access to welfare by the host state. And the same rule applies to persons who are staying in the host state as job seekers under the old Antonissen case law. Second thing, Article 24 also said, well, for the first 5 years of their stays, citizens who are not pursuing an economic activity may be excluded from maintenance aid for studies that consists in student grants or student loans, okay? So basically, member state had the right to exclude EU students from grants, student grants for 5 years, for the first 5 years of their stays. Well, if you had been following me before, you will not only realize how closely this reflected welfare tourism fears, but also the tension that this introduced between secondary legislation of the EU, Directive 2004/38 itself, and the case law of the court, which was interpreting the treaty. So the case law of the court was interpreting hierarchically superior law, okay? So why did I say that it so closely reflects welfare tourism preoccupation? Because if you look at that, all the categorical exemptions from social assistance target the at-risk categories from the standpoint of social welfare: the non-active, the job seekers, the students, okay? And if I say that it was in tension with case law, well, let me recapitulate that for you. In Martinez Allah, the court had said EU citizens who are there legally basically have a right to invoke non-discrimination. It was in doubt at the time whether this was still good case law, but it was there. Apparently, Article 24 was shutting out of equal access to welfare whole categories of EU citizens. How could you reconcile the two? And then you had more specific case law, Collins, Peter, saying, well, job seekers have a right to at least some forms of social assistance if they have a genuine link with the local labor market. How could you reconcile that with an article saying job seekers can be excluded from social assistance. And there was another case law saying, Bidar, which I mentioned before, well, students, if they are sufficiently integrated, have a right to an equal treatment. Of course, member state can check if they are sufficiently integrated. And the right to equal treatment extends to student grants. How can you reconcile that with a rule that says for the first 5 years of their stay, students can be excluded from student grants? So there was, at the time when the directive was adopted, there were lingering doubts as to whether it was compatible with the case law of the court. And there is here an interesting in-between phase of court case law that is the first, and I'm referring to the case law in the second half of the 2000s and the very beginning of the 2010s. It's the case law in which the European Court of Justice is trying to digest the new provisions of the directive and work out the issues. And here there is a point that, having perused social scientific literature on the matter, I feel compelled to point out. Social scientists tend to conceive of the court as something of an omniscient actor, or at least an actor that sees itself as omniscient, and which, like the oracles in ancient Greeks, speaks the truth once and for all on the issues that are submitted to it, sometimes obscurely, but ever without doubts or without hesitations. That is a bit of a caricature of how social scientists see the court, but close enough. And I would say that that is a very inaccurate representation of how the court works. The European Court of Justice usually gets to legal issues years later, because it takes a lot of time to legal issues to come before it. And it tends to settle issues gradually. To quote the current president of the court, stone by stone. So there are judgments where they start working out the implication of new legislation, and you have to wait a few judgments before you can say that the court has taken a new orientation, okay? And this is what happened here. In the first years, the court is trying to solve the first and most pressing issues. Is Article 24 of the directive invalid because it is in conflict with the treaty as interpreted in the old case law? How do we square the two? And interestingly, the court took a rather deferent position. For instance, in Förster, it said, well, I confirm that EU students have in principle the right to access student grants, but member states can check if they are sufficiently integrated. This is the old case law. And if I look at this case law in light of the new provision, I tell you, member states, that I consider it proportionate if you impose a waiting time of 5 years before you accept that the student was sufficiently integrated. You see what the court did there? It maintained the old case law, but it read it in such a way that it was compatible with the new provisions, or that the new provisions were compatible with it, okay? And the same thing happened for job seekers, even though a bit differently. Here you have Collins, the old case law, saying job seekers have a right to access all the benefits that are geared to give access to the labor market. And on the other hand, you have a provision saying, well, job seekers can be excluded from all of social assistance. In Vatsouras, which is a case of the late 2000s, the court says, well, no, Article 24 is not invalid. It's not in conflict with Collins, but you need to interpret social assistance there in a way that preserves the right of job seekers to the benefits which are specifically designed for access to the labor market. So here the court says, well, you have to adjust the reading of the legislative provision to the old case law. It's a bit of the inverse of what it did in Förster, but it still is the same kind of approach of trying to square things rather than doing what many legal commentators wanted the court to do, which is simply to strike down the new provisions as incompatible with the principle of non-discrimination. Okay? So as the decade turns, there is this beginning of a case law, but there are still a lot of issues on the table. And this is where we come to the last chapter. And one of the issue was, we still have Martinez Allah as potentially good case law. Can EU citizens be excluded en bloc from any welfare benefit, or shouldn't that always be a matter of rule and exception that is decided on an individual basis? And what are sufficient resources anyway under the directive? This was not yet clearly established, and so on and so forth. And the Dano generation of case law, the one that was the focus of so much discussion and controversy, is the court responding in the 2010s to all these questions. Now, given time limitations, and I'm keenly aware of the fact that I have more or less, if my calculations are right, 10 minutes more or something like this. I'm looking in the direction of Jean-Thomas to get confirmation, and I get confirmation. That's great. So given time limitation, what I could try to give you another panoramic view of all the case law that came since, or to choose a pinpoint perspective and to look more into detail, to observe a little bit more finely the dynamics at play. And I much prefer the latter approach. And I want to do this picking one case, and the most paradigmatic of them all and the most controversial of them all, and the case is Dano. And before we look at what the court did, let's take a look at the background and at the questions that were submitted to the court. The background is, let's jump back to 2004, 5, and 6. That is to the time right after the new directive with its new restrictionist provisions is enacted. As you all know, an EU directive must be transposed into national law, and member states generally have 2 years to do that. So Germany dutifully decided to transpose the directive in its own legislation. And not coincidentally, given that it had been a big player at the negotiating table of the directive, and that there were intensive fears of social welfare in Germany, looking forward to the time when free movement with the new member state would become entirely effective, which it was not, because Germany availed itself of a transitional period. Well, I was saying, given that Germany had a very heated debate about welfare tourism, there was a transposition of the directive with new welfare legislation that excluded EU nationals, I quote, who are in Germany solely for the purpose of finding a job from the basic insurance for unemployed. Okay, so Germany transposed the directive, and in doing so, it introduced a new restrictive law that excluded all those that were considered to be in Germany only for the purpose of finding a job from the most important basic insurance scheme. And this reminds, of course, Article 24.2. It sounds like it a lot, doesn't it? But as I pointed out, at the time, it was a bit unclear whether Article 24.2 was valid at all. It was unclear how it should be interpreted and applied. And at any rate, this way of applying it was clearly at odds with the old case law. Because for the nth time, sorry for repeating myself, it was purporting to exclude whole categories of EU citizens from basic welfare entitlements, where you still had case law like Martinez Allah that said that EU citizens legally staying basically had the right to access those benefits. So not surprisingly, and especially after the transitional period post-enlargement expired in Germany, there was very intense litigation. And I am quoting from an article that Angie and I have quoted in our article. So it's a quote of a quote. It's a squared quote. There was much litigation and quote, a fair amount of divergent national jurisprudence. And in particular, there was a very clear and very contentious split between the General Federal Social Court, which tended to rule in favor of EU citizens claiming benefits, and the lower courts in the Länder, not to mention political authorities, but I leave political authorities outside. And Dano came before the court, or the European Court of Justice, precisely at the initiative of one of these Länder social courts, the Leipzig social courts, which referred a whole block of questions to the court on how EU law should be interpreted. Now, here I will point out 3 points about the reference that the Leipzig Social Court made to the European Court of Justice. First of all, the choice of the case was quite clearly strategic. So the Leipzig Social Court did not choose a case where you had an applicant, a claimant that was, you know, borderline, somebody who could claim the benefits under EU law. No, it chose what has been defined in another article, a textbook case of welfare tourism, a case where the claimant had no work, was not looking for work, had no resource of her own, was legally there, but clearly had no right to stay under EU law. She was legally there under German law, which is of no concern to us, but she did not fulfill the conditions of EU law to stay there. And yet she invoked EU law to claim additional welfare benefits. Second point worthy of note, the formulation of the question. The Leipzig court was asking the court to clarify whether persons in this position can ever have a right under EU law to equal treatment in welfare matters. And in doing so, it emphasized the request to have a comprehensive and clear-cut answer. It mentioned every rule in the book, every EU rule in the book, and systematically asked the court, well, can a person in this situation request welfare benefits under this rule, under that precedent, under that rule, and trying to really get all the equal treatment rules in the EU law book. And why did it do so? Because if you read the reference to the court, the Leipzig court really emphasized that German authorities, German courts needed clear, workable rules, and that the case law of the ECJ itself was, by virtue of its being quite fuzzy and of being quite out of sync with the new legislative provision, creating a lot of controversy and confusion. Third point, the Leipzig court really explicitly took a stand. I mean, it did not refrain from pointing out to the European Court of Justice that answering yes to any of those questions, answering yes, those persons have a right to equal treatment in welfare matters, would have very detrimental consequences and open, so to speak, the floodgates of welfare tourism. Not my rhetoric, but the Leipzig court's rhetoric. Not so open, but quite clear. Okay. And of course, the German government before the court, because the governments always can present their observation to the court, doubled down and pointed out that indeed there was such a risk. And the judgment of the court was a direct response to all these points that were raised. I will not go too much into the technical details because you're all very tired of hearing me discussing ECJ case law. I'll try to keep it as simple as I can. Well, the first point that the court made, and it's a new point, technically speaking, was that Article 24 of the directive, the new provision excluding some citizens from non-discrimination, took precedence over the general prohibition of non-discrimination found in the treaty. So this was kind of new, kind of debatable, but even the most ardent critics of the court acknowledge that it was a legally sustainable interpretation. Okay, And it took what we saw in Forster one step ahead. It said, well, where the special provision that excludes some persons from non-discrimination is applicable, the general provision does not apply anymore. And in this way, the court, first of all, deferred to the legislation. It's to the legislator. Very clearly, it said the choices of the legislator take precedence over my interpretation of the treaty. This was a very important point. And the second point was that it kind of, created the legal clarity that the court was asking for, at least insofar as the categories of persons excluded under Article 24, job seekers, students, inactive citizens, in the first months of the stay were concerned. It's very noteworthy that the court said all of this, as we lawyers say, obiter, meaning that Mrs. Dano was not concerned by this. The court said it to be complete in a way, because Mrs. Dano was not one of the persons to whom Article 24 was applicable. Yeah, she was not a job seeker. She was not in the first 3 months of her stay, and she was most definitely not claiming student grants. Okay. As to the point of Mrs. Dano, the court finally gave decent and official burial to the old Martinez Allah case law. Whereas in Martinez Allah, the case had said every EU citizen legal staying has a right to equal treatment in welfare matters. In Dano, the court clearly said only those EU citizens who fulfill the right to stay under EU law have the right to claim equal treatment in welfare matters. And if a person doesn't have sufficient resources, so does not fulfill the right to stay in the host state, they have no right to claim welfare benefits under EU law. Again, it was a change in respect of the old case law. It was a new doctrine. It killed Martinez Allah, and it gave the Leipzig court the clear-cut answer that they were looking for. Well, sort of, because the term sufficient resources is very fuzzy. We can go there in the discussion if you like, okay? But was it a complete break in regard of the previous case law? I don't think so, because Dano, in this respect, just took the logic of the Drelchik case, one of the heroic cases, and adopted in many other cases, and took it to the final consequences. In Drelchik, the court had said, since you, Mr. Drelchik, fulfill in general the conditions of sufficient resources, you have the right to claim welfare benefits to overcome a momentary difficulty. In Dano, the court just says the same thing in the negative. Since you, Mrs. Dano, have no resources of your own, you cannot rely on EU law at all, neither to stay there nor to claim EU benefits. Okay? I think it's time for me to come to my conclusions. And at the end of this lengthy story that I told you, what can we say? Was there a change in the direction of the case law? Sure, there was. Actually, there was all the time. There was a change from Martinez Allah to Drelchik in the early 2000s. There was a change from that case law to the case law of Forster and Vatsouras in the late 2000s. And then there was further change in the case of Dano. And I won't deny that the change was one of gradual settling of the case law in a restrictionist sense. Okay. But was Dano a striking break in respect of the previous case law? I hope I have been able to demonstrate, at least on the strength of the materials that I presented to you, that it was not. That it was rather a matter of having a rather fuzzy case law that slowly folds into line and fits into a clearer mold over the 2000s and 2010s. And how can we make sense of it? Why did the court choose to clarify its case law in the restrictive sense and not in the expansive sense? Well, one thing that is kind of important to have in mind is that, to an extent, deference to the legislator is a standard expectation when it comes to Supreme Courts and to constitutional courts. Okay, we may debate this, we may discuss, even in respect of the European Court of Justice, but it's an important point. And clearly, the adoption of Directive 2004/38 played a major role in pointing the way to the court in terms of which way to develop its own case law. So there was a dialogue between the court and the legislation and the legislator. And I tend to be a little bit skeptical of description of the court as a free agent that took it on itself to, in a legally puzzling way, make a U-turn. The second dimension of the dialogue, which is perhaps more interesting to social scientists, is the fact that the European Court was patently, in the case of Dano and in some other judgments of the era, very attentive to the signals coming from national actors, national courts and national governments, who, I used Dano as an example, but we could multiply the example, represented to the court a situation of legal unclarity and unsettlement deriving from the court's own case law. And nothing is as uncomfortable as legal confusion for a top court like the European Court of Justice. So it is the new case law, you can regard it also as a result of intense iterative interaction between the court and the national actors, who are then those who have to apply EU law in the last analysis. And on this note, I will stop here. I am afraid that I've taken a couple minutes more than was allowed, and I leave the floor back to you for the discussion.
Thank you very much, Francesco. Actually, you finished right on time. And I think we move on straight to Jean-Michel's comments for about 10 minutes, so that we still have time for discussion. Thank you very much.
Thank you very much, Francesco. Thank you also, Jean-Thomas and Gianni, for the invitation. So this has been a very rich presentation, and most of you haven't seen the paper, so imagine the paper is even much richer than this. I really enjoy having a look at it. Now, I think the great quality of this paper, and I think of the talk as well, is that, especially for the social scientists among us, is also to remind us of the importance of not overlooking court cases when we want to try to talk about migration and welfare, naturally, in the European context. But of course, the paper has, and the presentation had many more qualities than that. I am not a lawyer, yet I do not see the court as an omniscient actor, but how I will try in the coming minutes to make maybe 3 or 4 points about maybe how modestly a social scientist's perspective might bring some elements to the paper or to the discussion that could maybe further develop later. The first point, and unfortunately you had to go very fast, so of course a few things are in the paper that you couldn't develop today, is the element of history and of the origins, which you briefly touched upon at the beginning of your expose. And I think it's interesting to remind maybe those of us here today who are not necessarily so familiar with the case, that indeed, as you noted very well, freedom of movement and access to national welfare systems were really considered as key to the success of the European integration process. And there was a lot of rhetoric around that to encourage people to move in the post-war context. And this came naturally from even earlier in the 20th century, or even sometimes in the 19th century, where European states, especially Northwestern European states, had used their welfare systems to advertise job opportunities abroad. If you take the cases of Belgium, for example, trying to convince southern Italians to come and work in the coal mines of Belgium. Okay, now, so we often see the EU integration process as the beginning of a process of certification of rights, where by which, by encouraging mobility within the EU, at the same time we're closing the borders to the others, and we make it more difficult for third country nationals to come in and to access our welfare systems. And I think that has not necessarily been said, but it's important to remind it. And since you mentioned your interest in asylum law, and I think it's also critical to see how this logic is important. This logic of openness and closure has consequences for third country nationals. And it's really interesting in this regard to have a look at the work of P. Johansson and Stefan Johansson, for example, who showed how it could have been different, for example, in the early days of the EU integration process, where states who had former colonial ties or still some form of colonial connections, of protectorate connection, were arguing actually for different types of circulation rights for people coming from outside of Europe. But yet it's not the decision that was made. The decision that was made was to favor a kind of a more closed system of circulation between EC member states. And what happens many decades later is that not only have third country nationals, of course, lost a series of access to national welfare systems, but also now we've seen that there's been, as you showed quite clearly, there's also been a series of decisions that have made access of EU citizens themselves more difficult to welfare rights. So I think that's an interesting element already to contextualize. Now, I guess my 2 or 3 comments will focus on maybe on the politicization of those debates, and naturally it's not necessarily your angle, but I think maybe as a way to kickstart the discussion, maybe to try to bring some of that too. And again, as you mentioned, there's no such thing as an omniscient court that is disconnected from society and etc. So I think it's very important, and maybe slightly less developed in the paper, to also remember that the developments of the early 2010s cannot be disconnected from the socioeconomic context of that period. And we're talking about the 2008 economic crisis with the reopening of Southern European migration routes, which see strong increases of Italian, Spanish, Greek migration towards Northwestern Europe, and basically governments from the south of Europe also denouncing distortions of EU free movements, them denouncing on the one hand, well, you're don't want to bail us out, and at the same time you're accusing of our citizens of welfare tourism. We kind of caught in a bind here. Our citizens have to move because we are caught in this crisis, and yet you blame them for being mobile. Okay, and here I think it's not necessarily the usual suspects, but some of them were the usual suspects. You had the UK, Germany, Austria, and the Netherlands, some of which to be known later on as the frugal member states, were really critical in this process. I remember being in a meeting at the European Commission, where mayors had been invited from several German and Austrian cities, and really making a plea to limit freedom of movements because they were supposedly flooded by not only Southern European but also Eastern European citizens moving during the economic crisis. So first element, which connect to one of the main point I wanted to say about the consequences of these court cases, which is not only about limitations of rights, but also about something that the court appears to be blind if you read the court decisions, but might not be so blind when you see how the court decisions are being instrumentalized by member states. And I'm talking about Martinez Allah, and Dano. And you mentioned something about bringing citizens to the door, and that's where I want to go, about the implementation of those decisions. And very often we make shortcuts, and I do that also talking about expulsions of EU citizens or removal of residence permits, and it's not necessarily always very clear what we mean by removing, by limiting those rights to welfare. And I think it's quite interesting to go a little bit into those details, because I think there are important inequalities between EU citizens. Now, if I'm not mistaken, the Citizenship Directive provides that people can be expelled also if they represent an imminent threat, for example, for the security of member states. But then, when it comes to welfare, there it's a little bit more confusing as to what is meant exactly by termination of the residence permit, or ending the right to free movement and things like that. Now, my point here is that if we take the examples that of member states who have used kind of a large-scale basis these kind of welfare provisions to limit rights to freedom of movement, there is, I think, an important ethnic dimension, which I think the court, and I would like probably to hear you on this, consciously or unconsciously might be culpable of, or might be associated with. So if you look at, for example, the Sarkozy government in France and in the 2010s, and the policies towards Roma migrants, already EU citizens at the time, most of them from Bulgaria and Romania, where even though it was shown as forcible removal, and it was with huge public displays of destruction of Roma camps, etc., it was actually done in a way of like strongly encouraging people by removing the residence permit, but also paying tickets for people to go back, knowing that the actual police intervention and the actual forcible removal of people at the border would be something in the EU that would be badly perceived. Another example, and maybe a little more nuanced than the Sarkozy approach, was the Belgian one, where again, people who had used social assistance in the early 2010s until today, actually, are found to lose their right to reside in Belgium on a quite massive scale. I'm talking about 15,000 people in about 5 to 7 years. And here again, if we look at the statistics and who is actually losing their right to reside in Belgium, again, we see that it's mostly Slovaks, Romanians, Bulgarians, Romanians in particular, who are targeted by this. So here, what I find interesting is that even though the case law, of course, does not automatically reflect the political context of the time, it cannot be completely disconnected from it either. But yet, the ethnic dimension that seemed to be underlying in the political interpretation of it, and I would like to hear you about this, and how how that could be somewhat taken into account in the legalistic approach that you're doing of those cases. And then, since my time is running, then maybe my last point would be about, I think, something that quite a few participants today might have interested in, as there are quite a few citizenship scholars in the room, I think, is about the side effects also of these decisions and of the legislative adaptations to these decisions. Across the EU, it's become increasingly popular, and we know this with the work of Global Cit, for example, that to use welfare or non-use of welfare as a criteria for accessing citizenship. And there's been some really restrictive interpretation of it, including people working in subsidized form of working, or people working for even international institutions, and because they don't pay taxes, being denied the right to citizenship because they are interpreted under the Citizenship Directive by these governments as welfare abusers and as people who don't contribute to the welfare systems. And so here also, maybe I guess as a reaction to the presentation, also a little bit about, how can also a legalistic approach to these issues also take into account the kind of side effect dimension of it beyond the issue of welfare, which is obviously central to these decisions, but actually has consequences of lives of EU free movers much beyond the right to reside, but also, in this case, the right to access nationality and citizenship. Thank you very much again for the invitation and for the excellent presentation. I really enjoyed it.
Thank you so much for the comment, Jean-Thomas. How do we proceed? Do I
well, it's very much
discussion already, or would you like to have a round of discussion? Whichever way is fine with me.
I think you may take a few minutes to address, the points that seem to you most relevant.
No, I won't take long, but
don't take too long, and then we open up. I mean, I do have a question myself, but I definitely give the premiere to the rest of the audience.
Okay, so, I'm very thankful to Jean-Michel for the many points that he raised, and they're all extremely valid points. You say humble social scientist. Actually, it's a bit the inverse. Humble lawyer among social scientists, or at least this is how I meant my little interdisciplinary fencing. But let me go to the central point that you raise. The case law cannot be disconnected from the political context in which it matures, and that's certainly a point to which I would subscribe 100%. The thing the argument that I more disagree with is the argument that the court takes into account of political realities in an unmediated way, shall we say, so that the court acts on the basis of opinion polls, etc., and steers its case law in that way. This tends not to be the way in which the court works, and in this case, it's interesting. The thing that Angie and I have examined most closely in our article is not that the court is outside of political influence. To the contrary, I think that we make a very strong argument that the court is reacting to its political context in two ways. To the EU interinstitutional context, which is a political context, of course, and a constitutional one. You have a top court which is faced with the choices of the legislator, which itself is supposed to reflect the views of the citizens of and of the states. And on the other hand, clearly, there is also a reaction to what goes on at the implementation level. And the context, the thick context that you recall certainly has great importance. But the point is that this context, the one that you recalled, for instance, with mayors of cities requesting a suspension of free movement, etc., etc. But the way this comes to the court is always mediated in a way, either through the filter of the legal community of which the court is part, which is the national lower courts, which are those who put the questions to the court. And the reason why I insisted so much on the role of the Leipzig court is that, of course, asking questions to the court is never a neutral exercise. The court that asks the question to the court nearly always has its own agenda. And this shows in the choice of the test case to be sent before the court, in the choice of the questions to ask to the court, and in the formulation of those questions. So there is very clearly an agenda interaction. And then, of course, the court is faced with the conclusions of the government, etc. And through that medium, of course, the court is made acquainted with all the context. And I have no doubts that the judges, to quote from a very famous article, read the morning papers, and so that they are immersed into that context. And it's the context that you described as well. But the point is that in then choosing the legal argument and the way that they frame their judgments, there are kinds of rules of argumentation, rules of previous authority, and of response to the arguments of the parties that tend to structure the way in which then the court reacts. And I think that Dano and the subsequent case law is a very good example of that. To come to the question of the consequences, it's a big one, and it's a very important one. And there is no discussion that that those judgments are part of that movement of using precarious welfare rights to make stay more precarious or to deny access to full citizenship. So there is no real doubt that those judgments reflect this kind of Weltanschauung, or at any rate kind of contribute to that kind of, to those consequences. As to whether the court was race conscious when it made those decisions, I have no elements to say that it was or that it wasn't. I would tend to argue that, especially on issues of that are so politically heated, the court perhaps does not want to address the far consequences or ramifications or its decisions, while preferring to respond to the technical point that is put to it in a way that corresponds to the stimulations that come to it through the channels that I pointed out. But frankly, I have no way to know, or at least I do not know, whether you can see an impact, but it's not clear to me that there was an intent of targeting that particular population. So I have no answer to that, but it's definitely a very valid point that you raised.
Thank you.
Thank you, Francesco. So quite a few people want to intervene now. I suggest that we keep the questions quite short and you keep the answers quite short instead of picking up, so
I
that
see
you
a hand raised there.
Right. So we'll start with Ines Calzada.
Hello. Thank you very much for the invitation and for this wonderful presentation. I'm working in retirement migration. That's Northern Europeans moving to the south to retire and to die in the south. Then when they need social assistance, normally they don't have many years left. And I was wondering to what extent this makes a difference in legal terms, like they don't have 5 years to wait so that they can register. And then if they have been like 2 years, for example, or 3 years, but in Spain, but they need social assistance because they are entering into dependence, this old age, this urgency, I would say, does it make any difference legally? Like, thank you.
You mean the urgency of life expectations?
Yeah.
I take a few questions and then perhaps answer to them in block.
Yeah, question, but let's take 2 or 3. I think Gianni and Daniela as well. Start with, yes, Gianni, you have a question, as well as Daniela, as far as I can tell.
To Francesco, really, I like very much your dialectical talk, because you pretended basically at the beginning to show a sort of evolution, a sort of U-turn, and at the end it showed that maybe it's not so dramatic as you showed. And I was questioning myself now, arguing as a social historian, if this is really something new, or what was the naivete of the late 70s, 80s to pretend that on a common union, basically everything would change and there would be the creation of a new post-national citizenship status. If we are going back basically to the welfare, if you are going back also to national welfare systems in the 19th century, to the poor law of Charles Dickens, to the situation in Switzerland, basically the poors, the undeserving poors, were re-socialized or removed from the area where they were. This is an historical way how to handle the issue of those who are a burden. So the issue after World War II was basically that for economic reasons, people had to move. And the social citizenship issue has been the entry gate in order to create an enlargement of residence permits for these people. And there has been, as Mihan said, in the 90s, a sort of spillover. The people who gained economic rights and social rights more and more basically were asking also for more citizenship stable status. And these created the need, basically, also for enlarging the citizenship status. Now we are confronted, after 2004, with an enlargement of the European Union and the issue that new poors risk to come. Why should we really be so surprised that in such a situation, basically the old mechanisms to get rid of those who are not deserving has entered into function? I tell you something. In 2014, I was a member of a German expert committee in Berlin. And the head of this committee was later become one of the federal judges of Germany. And her fear in waiting for the Dano case, and we were also writing a report on the situation of Romas in Düsseldorf, was that basically the ECJ would argue in favor of the pretension to maintain social assistance and social rights in Leipzig, because this would have jeopardized basically the legitimation of EU law within the German territory. So, I mean, I'm not a legal scholar, as you know, but during legal philosophy, I learned that customs, the way how you interpret the signs of the time, plays a role. And obviously, something changed since the 90s. Do you agree?
Francesco, perhaps you could address those two questions? And
Fine.
we have another round of two questions afterwards, Daniela and Alexis.
To Ines, this is a very specific question, and I'm afraid that I don't have a ready answer to that. Not to my knowledge. I mean, the life expectation of the person who is asking for a benefit is not in itself a relevant consideration in the interpretation of those provisions that I know of. So, for instance, there is this waiting time. It's not because you are, for instance, sorry for picking such a horrible ideal case, but it's not because you would be terminally ill that you can request an exemption from the Article 24 5 years waiting time in order to get a grant. Not that I know of. There are no judgments of the court that I think go in this direction. To Gianni's point, I really agree, and there is one element in the literature that deals with the ECJ case law that to me is quite striking, and it's the amount of idealization that is made of a certain phase of the European Court of Justice case law. If you take that case law from the end of '98 to mid 2000s, it's usually very well commented, and it's on the strength of those important rhetorical phrases, une certaine solidarité, and so on and so forth. But then, if you look at the legal substance of what is decided in terms of gains and of obligations and of rights, it's always so evanescent, right? It's always to vanishing point, and as if it was the fog of something that could have perhaps built into. Then there was a strong wind, and it went away, and we are left with Dano and the other cases, which are as if it was, one of the possible developments of the case law, and it goes in the sense of allowing member states to restrict the rights of the most marginal. And I think that here we are going back to precisely the points that Jean-Michel made. So I completely agree. There is, however, another point that I would like to make. Even though they're a little bit at risk now, there are a series of what in European jargon are called acquis, meaning things that have been acquired over the time in terms of rights, in terms of acquired rights, etc., and that have not gone away, and that tend to protect precisely the working poor. As soon as you are able to make the connection to the sphere of being in work somehow, you have some effective appeal to EU law. You may have all the national administration against you, but in the end, you may manage to succeed. okay? But you need to be able to connect to those more solid statuses in the court's case law. And a cynical would say that those cases, those statuses have remained solid because they are integral to the internal market project. They're integral to the core economic constitution of the European Union. They were too deeply embedded to be shaken by this, okay? So it's a story that is full of nuances, but in the main, yes, I certainly agree that there was a hope that remained a hope and never really materialized, and that the hard realities of the economic crisis, in the sense that we all discussed so far, probably had a strong impact on what the court decided. Hope I managed to give some elements of answer to Gianni and Ines, and look forward to more.
Yes. Unfortunately, we don't. It's so I think we have more questions. It's already 5:55. We can take an extra 5 minutes, of course. But I think Daniela, you had a question, and so did you, Alexis.
Yes. First of all, thank you very much for this very rich, very insightful presentation. I have 3 questions because I'll try to be as brief as possible. So the first one is mostly a comment starting from something that you said at the end, this reference to ECG judges read the learning papers. So you mentioned at the end that the court was indeed sensitive in its interpretation to what was happening at the domestic level, either in national courts or in national governments. So do you actually believe that we can give a clear-cut answer of how this turning point was actually driven by these increasing fears of welfare tourism? Fears that, of course, can be observed at 2 different levels. On the one side, at the political level, with the political pressures that you mentioned, with the increasing politicization of the topic, but on the other side, also at the societal level, because we've also seen very restrictive public, increasingly restrictive public views towards free movers' access to welfare benefits, and this idea of the undeserving other. But then again, of course, the puzzle gets more complicated when timing comes into play as another element of complexity, right? Because this shift in the legal interpretation also happens in this context in which we have shifting dynamics across Europe. We have the intensification of intra-EU mobility as an effect of this successive EU enlargement waves. We also have a diversification of the different categories of mobile individuals that could potentially gain access to welfare entitlements. We also have a more vulnerable socioeconomic context, as Jean-Michel was saying. So thus timing remains an important element when we try to understand this shift in the legal interpretation, because Martinez...
Daniela, excuse me, but I'm having a hard time following your question because my audio is not perfect and you're speaking very fast and I'm not being able to understand what the question is.
All right, so my question was whether we can give a clear-cut answer to the extent to which this shift in the legal interpretation was mostly due to fears of the welfare magnet, fears at the societal level, but also at the political level, because these have been coupled in many member states, or on the contrary, to the timing of the judgments, because Martinez Allah happened in a very peculiar, let's say, context of the European integration process, happened way before the diversification of intra-EU mobility after especially the 2004 and 2007 EU enlargement waves. So is it surprising at the end of the day, as Gianni was saying? And then I have another question about what you said about the possibility of member states to actually check the level of integration for students or the genuine link for job seekers. So I was wondering here to what extent this fuzziness in the legal text and this legal margin for discretionality, if you wish, was translated into quite varying responses from the member states. Did it lead to legal loopholes that were actually instrumentalized afterwards, as Jean-Michel was saying? And what about cases of non-compliance from member states in the transposition of the EU legislation? Can you give us some examples of infringement? Because we've heard many cases from Austria, for instance, but I'm not too sure what is going on in other member states. Thank you very much.
Right. I suggest you stick because it's now time actually, and I would very much like Alexis to have a chance to give his question, to ask his question afterwards. Could you stick perhaps to the second, because the first argument was somewhat addressed when you replied in your reply to Jenny. Perhaps stick to the second one. Francesco, you have to switch on your micro again.
You're right. Sorry. Those fuzzy passes in the case law are there for a reason. I mean, the many aspects of the court's case, not only of the court's case law, but in general of EU law, are predicated on the member states being able to make an assessment of several things, of whether a person is a danger to public order, or of whether a person is sufficiently integrated in the labor market, or whether it has a genuine link. So it is somewhat pre-programmed that those are areas of some discretion for the member states, or at least notions that are vague on purpose, because then they are allowed to evolve as the facts on the ground evolve. So the fact that there are different responses to that is not in itself a dysfunction of the system, so to speak. Okay, it's somehow part of the system. Of course, if you go back to the cases like even Collins, which is a case where there is a very open discussion there on what it means for a job seeker to have a genuine link with the labor market, and it's interesting because it's such an explicit discussion on welfare tourism. You would not expect it to be so really very at the forefront. And there you have the UK arguing for kind of draconian rules of residence, which were then very much part of the right to reside tests of later years. And the court instead saying, but softly, I mean, leaving margins to move, saying, well, what I have in mind is some kind of test that the person is actually looking for a job and not just pretending to, you know? So there is some space for conception. Then, of course, the court may move in and make those vague things into something that is a lot more specific and a lot more constraining, but it hasn't done so for those notions. It tends to, in case, jump over to, shall we say, processual considerations. There is this very complicated case on sufficient resources, where to a very straightforward question of whether a pensioner who has a modest income and asks for a top up can be considered to have sufficient resources or not, the court gives an extraordinarily complicated answer in which it tells to national authorities that they should assess whether the burden posed by that request is excessive in light of all the individual circumstances concerned, but taking into account the global burden that it would represent if cases similarly placed come up. I mean, the court is trying to give precisions, but since it cannot say what sufficient resources are in all contexts, it tries to give a kind of processual answer. I hope I've given some elements to your question. I want to leave time also to Alexis to ask his question.
Yes, it's a shame that Ines Calzada had to leave us, actually, because I think what you just mentioned, and we could actually have another, we won't have time, unfortunately, but this aspect, minimum resources, which have become basically the dominant criteria of qualification, of free movement and access to social protection in Europe, is actually quite fundamental. And that's something that hopefully we'll get a chance to develop further during the workshop. Sure. Alexis, we're already 4 minutes behind the clock, but please ask your question. And feel free to, well, I think everybody can wait for another 5 minutes. Sorry about that for not meeting the time, but I think that's what happens with interesting events. Actually.
Okay, so very quickly, do you hear me well? Very quickly.
I do.
I think what was supposed to be a question now is becoming a comment, given all that has been said already. The only idea that I wanted to play a bit the oversensitive political scientist in the room, saying that, of course, maybe political scientists think that the court is omniscient, which I don't think.
That the court is
omniscient, that it knows everything. But it surely is a black box, and I think this is one of the problems in what gives a bit of frustration in all your very interesting explanations, is that we don't really manage to assign preferences, goals, and aims here to the court. It's very difficult to know at which point what is the court pursuing as an objective and why. And this question is a political scientist question, and it's very difficult here to not fall into kind of equivalent of explanation, where the question is very interesting as to whether the court needed time to digest the 2004 directive, whether the court was sensitive to enlargement and rising Euroscepticism, whether the court wanted to give clarity given the emerging functional problems as a result, or whether the court wanted to not be too much in opposition with member states' interest, which, by the way, became very different after enlargement. Because, of course, a lot of member states were low-standard countries, and you said that a lot of member states were seeking more mobility for the citizens. So all of these explanations kind of run counter to each other in a way that is, I think, always a bit frustrating when we look at the court. It's not specific to any research. I mean, it's specific to all research on the court because we cannot really assign preferences. Because it's still a black box. It's very difficult to have interviews with 12 judges from the court. They usually don't give it, and you cannot really assign different preferences because they know very well how to consult it, because of course they cannot have political preferences. So this is one of the problems which lead to another, which is more of research design, which is that you said that the court is very sensitive to saliency in political problems. And
is very sensitive to
saliency in political problems, not overstepping on sensitive issues in order to not take part in too salient political debates.
With reservation, yes, okay.
Yeah, of course. But then it's very interesting to know that at the same time, I'm not claiming synchronicity here. But it's very interesting that at the same time, when the court was supposed to be very sensitive to this issue, then it started stepping into the Laval Quartet and the question of the conflict between the freedom of movement and the right to strike, which seems to me to be very salient, and which has been decided in a way that is very salient, and which created a lot of conflict in the European Union. So my question and my last question would be, how do you make sense of all this?
Okay, it's quite a bit quite a bunch to digest and to give answers in 3 minutes, but I'll do my best. Well, first of all, not only the European Court of Justice is a black box. With due exceptions, courts tend to be black boxes because of institutional duties. They cannot openly flag political affiliations or political tendencies, and they are bound, judges, to reserve when they discuss matters on which they are bound to judge or which they have judged. So that is not surprising. I mean, courts are themselves difficult objects to analyze in terms of process tracing and whatever you want, because you generally don't have the materials, okay? So given that, I try to go with some of your questions. Why did the court need time to digest? I would point out that prudence and going step by step is not the exception. It is standard judicial practice whenever courts are faced with new questions. I mean, how many times have we seen the Swiss Federal Court itself saying, I don't need to answer this question that is put to me, so I leave it open because I can do this and that in order to solve the issue. And those are very often cases where the federal court doesn't want to answer yet. Why does it not want to answer yet? It may be, well, generally it's legal issues that are at the fringe. If there is a self-evident answer, that tends not to apply, okay? But if you've got many and the implications are big, in economic terms, in political terms, etc., courts may need to have more time to be fully apprised with what they're doing in terms of the consequences, or they may just be split. If an issue is salient, there is a good chance that the court is split within itself. And so they are just unable to give a clear-cut answer on a point. Sometimes you find passages, especially in a court like the European Court of Justice, which does not allow separate opinions and where there are no public votes. They need to find an argumentative thing that brings everybody on board. And so sometimes you find judgments that are extraordinarily obscure. Why? Because they needed to compromise. They needed to save the arguments of this and that. So these are several reasons why the court may be a little bit procrastinating and going slowly. The second thing is I need to qualify the statement that I made, that the court is not a court that is willing to enter into politically sensitive issues, because taken at face value and in the absolute, it's just plain wrong. I mean, the European Court of Justice is a court that is known for having taken decisions that were politically of a massive importance, and in some cases that were very controversial, and in some cases that were totally contrary to the stated preference of the member states, okay? So there needs to be some qualifications here. And the point is, again, that probably, but again, we will never exactly know. What we can work on is the argumentations used by the court, the structural constraints that the court face. I mean, for the court, it's always pretty bad if they have to depart dramatically from a previous case law. That's kind of an argumentative structural constraint. You can try to work out the policy of the court, triangulating from these other elements, but clearly in the case of, say, supremacy of EU law, the court has a big stake and it's willing to go, you know, to bite the bullet and go down to confrontation if it's needed to save the constitutional structure of EU law. Probably it was not disposed to go that far for the rights to welfare of a person who is even outside of the scope of EU-defined rights of free movement. I'm referring to Dano, of course. Okay, so there is a matter of, if you will, constitutional agenda. And as Gianni said, the vague constructions and laces that the court has started building at the turn of the century all went away when it became apparent that the court didn't have the member states behind it, didn't have the national authorities that are meant to implement EU law behind it, and that probably that there was also a public temperature that was really unfavorable. And here we enter again, Daniela, in the discussion of whether it's the morning paper or whether it's the arguments of the German government. I mean, it's probably both of them, but in terms of the specificity of the pressures and how they show in the arguments used by the court, I would always argue that it's the direct interlocutors. But this is what I can say. I don't know if it's a complete answer, but it certainly is one that took a lot of time to say.
No, that's perfect, Francesco. I'd like to thank you because you perfectly met my expectations. It was you brushed the broad picture, a lot of very challenging and arguments, and quite a bit of food for thought for the coming workshop. That unfortunately you won't be able to attend, but we have quite a few people from your team. I'm thinking of Tino as well as NJ, who submitted a very good paper, so they'll be filling the spot for you. And we were a tiny bit late, so we'll probably, but I expect most of you to meet us again starting at 9 o'clock on Thursday. The WebEx address is different. You will connect to my own account. There will be no password. And if some of you who attended the talk but are not part of the workshop would like to attend some bits and pieces of the workshop, which is